So after a very long wait, and I'm looking around the room and I'm seeing some very familiar faces that we've talked to a lot over the years, we've finally released a draft of the Therapeutic Products Bill, along with it our consultation document and the most recent papers that provide the Minister's advice to Cabinet. So I'm sure you've all found that package and have been working your way through it. We've also put our consultation program up on our website. This is our first session. We tried to design a program so that we could have this session early in the consultation period, really to give information about the bill. What does it say? What does it try and do? How is it expressed in the bill? We're aware that reading legislation is not that easy for people, so this is an opportunity to really understand how the bill works so that you can put the most into your submissions and we can get the most out of them, and we can really get a piece of legislation that we can all work with into the future. So thank you for your engagement today, and to those of you who've expressed interest in a forum later on in March. We'll be getting the details of exactly how those sessions will fall, times, venues, etc. out to people, now that we've got registrations in for those. I'm aware that some people may have got the information about those forums a bit late, so please do, if you still want to come to those sessions, or you know somebody that wants to come, do flick an email through to the Therapeutic Products web address, and Hannah and Pam will be able to take care of that for you. I think everybody knows me. I'm Sheila Swan. I'm a Chief Advisor in the Regulatory Policy part of the System Strategy and Policy Unit in the Ministry of Health. I'll be presenting the first part of our information session this morning, and with me are Susan, who's a Principal Analyst in the Regulatory Policy section and well known to many in the room, and Hannah Adams, who's a Senior Analyst on our team. And I have to give credit, these two are the authors of that consultation document that you have, an excellent piece of work by them. We also are pleased to have Chris from MedSafe, Chris James, Group Manager of MedSafe, and Andy Shercliffe, our Chief Pharmacist. Chris and Andy will be joining us as part of a panel to answer your questions in the second part of the morning. There's also a number of others from the Ministry team who are here and who've helped us along the way, so you'll see them around as well. Here's our agenda for the morning. We'll run through our presentation. That will take about an hour. There's a lot of material to cover. And I ask, please, could people save their questions so that we can run through? But do jot them down, and we've left a good hour for questions and answers after we've had a cup of tea. So I'm going to do a section on giving you an overview of our scheme. I will then turn over to Susan, who will talk through details around medicines and medical devices, and then she on to Hannah, who will talk us through the licensing aspects of the scheme. So I've certainly said it a few times to people in this room, but we need to move from the Medicines Act, from our 70s regulatory arrangements, into modern regulatory times. And, I was quite thoughtful when we were doing this bill. If this bill lasts as long as the Medicines Act, we're going to have this bill as an act in 2060. And then I calculated how old I'll be in 2060, and then I sort of stopped, going down that path. But that is the reality of what we're trying to do. And it's hard to imagine what products, services, practitioners will be around then. It's hard to imagine how our communities of need will be configured, what kinds of health challenges our system will be trying to address. When the Medicines Act was passed, there were a few things going on in New Zealand. We got our first ATM machine on Lambton Quay. IBM released the first laptop computer. And the first formal epidemiological reports of the AIDS epidemic started coming through the US Centers of Disease Control. So if we project ourselves forward, in 2060 somebody will be standing here going, God, they were really excited back then about Wi-Fi and, CAR T cells and, oh, goodness sake, that's such old tech. But for many of the products that regulators are now having to deal with were the stuff of sci-fi back in 1981, if they were even contemplated at all. And the ways we're using our practitioners weren't contemplated at all. So, as we've been designing this new legislation, we've been trying to lift ourselves out of the here and now and project ourselves forward and think, what are we going to need in 5 years, but also what might we be needing in 20 years and in 25 years? This piece of legislation is a very complicated beast. And, it's for a government, it's a really big undertaking to review and replace this kind of legislation. This will be in place for a long time. So it looks very different to the Medicines Act, as I'm sure you've noticed, and so it should. It's drafted very much using modern drafting style, where we try and keep as much as we can out of the legislation, but set up the core tenets that we need and then allow things in other instruments. And I'll come to that in a little bit more in another slide. So the basic structure of the scheme, and I do encourage you, if you haven't already looked at it, to look at the front end of the discussion document that gives you a bit of a map of what's in what bit and what part of the legislation does what. But the basic structuring is that all the definitions and meanings are covered in Part 2 of the bill. That's sections 14 to 50. So that describes all of the things, and then all of the controls and authorizations and things that relate to them are in the subsequent parts of the legislation. There's, just before I flick to this slide, it's also, I just want to draw to people's attention, if you haven't already seen it, that while most of the consultation document is seeking your feedback on how the bill is cast and what's drafted, there are, of course, two areas where we are seeking feedback at more of a policy level, and those are, of course, on pharmacy licensing and what the options should be for ensuring pharmacist control of pharmacies into the future, and on direct-to-consumer advertising of prescription medicine policy, where the government is explicitly looking for advice on what the policy should be in that area going forward. So the feedback we'll be seeking in those areas is of a slightly different nature than of the rest of the bill. But one of the very striking things that you'll have found about the bill is, despite its couple of hundred pages in length, actually a lot of the detail's not there. A lot of the detail that affects, all of the day-to-day work of the regulator and the day-to-day work of people in the industry and in the wider sector isn't there. It will be sitting down in the regulations and the rules and the notices. It's important to understand how these tiers of legislative instruments work. When you put them all together, you get the whole scheme. So the primary legislation sets out the purpose of the Act. It provides principles and criteria for the other instruments that are made under it. It gives permission for those instruments to be made. It contains, we have rules about what must sit in legislation. So things like enforcement provisions must sit in primary legislation. So it contains all of those types of things. The Act, as I think people know, is made by Parliament and receives the royal assent of the Governor-General, and there's a very formal process that we need to take that through. We will go from this process into refining the bill, into introducing it to the House, and then you'll all get another opportunity to comment on it when it hits Select Committee. and then it goes back into the House for its debate. It goes through several stages of debate. At all of those stages, changes may be made to it, and then finally it gets passed. So there's a long way to run on that. Regulations will contain a lot of the detail of the scheme, and in an enabling statute like this, there's always questions about, okay, so who makes those things and how do I get to have a say and what are the controls over them? So regulations are made by the Governor-General. There's a process whereby we develop them, we work with Parliamentary Council to draft them. The bill requires that we consult on them. The Cabinet Office manuals require us to consult on them. They then go in, those decisions are made by Cabinet, and they're made by the Governor-General. So there's still quite a lot of process around those, so we have quite a lot of comfort that those processes are suitable for the level of detail and the amount of material that we have put into regulations. But they are easier to change than an Act. Changing an Act of Parliament is an extremely difficult thing to do, particularly for material that is as detailed as this stuff is. Regulations are easier to make, but they still have quite a lot of process around them. The rules and regulation notices are designed for the next tier of detail under regulations that we might need to change more frequently. So I've given these presentations a lot over the last few years, and I think I've commented a number of times that we've tried to design this scheme so that we pitch it appropriately. The more certainty we want, the less flexibility we get, and we put things in an Act. And the more flexibility we want, and we certainly want more than we've got in the Medicines Act, we look to lower tier instruments. But there is a sort of a trust relationship there about how those things then get made. But as you're doing your submissions, I do invite you to be thoughtful that there's a direct trade-off there. The more certainty you want, the more rigidity you get. So, I think as people know, the legislation is designed at all therapeutic products. So everything is in. Medicines, what we're calling active medicinal ingredients, all our medical devices, and a grouping of things called Type 4 products, which is, it's kind of a bit of a funny category because at the moment we don't know what's in that box. But we have worked with the drafters to create this category of product for things that may come up in the future and we need a place to put them. We had the situation, I'm going to get the date wrong, I'm going to say 04, but I might be wrong, with xenotransplantation when that came in. Actually, we couldn't fit that into the Medicines Act. And we had to rush an Act of Parliament through to manage things called specified biotechnical procedures. That's not a great way to regulate. So what we've done is create a Type 4 product that gives us a place to put those products while we work out what to do with them and how to deal with them. I know there's interest in natural health products, and I hope you'll see in the consultation document the government has decided that it wants to think about how to regulate those as a separate matter, and I expect that there would be consultation on that in due course. We're working sort of alongside that group of people that's doing that work in the ministry. The bill puts in place sort of two broad sets of controls around products need approvals and activities need licenses or permits. Are the two basic chunks in the bill. There are, of course, exceptions, and we're quite interested in exploring how some of those ability to grant exceptions has been cast in the bill. I know we're thinking quite hard about the special clinical needs approach in the bill as a replacement for Section 29, and Susan will touch on some of that in off-label use. We're really interested in feedback on that. We think there's probably a bit of refining that we can do in that area. The bill also contains all of the activities that would be subject to restriction, and saying who can do stuff and when can they do it and what kinds of permissions need to sit around that and how do you go about getting such a thing. I'm just going to leave this up because I think Hannah will probably touch on this in her presentation, but this is a listing of the controlled activities which will require an authorisation of some type under the bill. But the bill does allow flexibility in how we authorise those activities. Some of the authorisations are given by the Act itself, such as prescribing, compounding, dispensing. Those permissions are given by the legislation itself. Some activities you'll need to apply and get a licence to undertake those activities, and the bill obviously talks about how you go about doing that and who can do it and what are the criteria. It also contains the ability for the regulator to issue permits, which are a sort of a slightly easier mechanism to use in more defined circumstances. In general, for particularly on the medicine side of the equation, the authorisations will look fairly similar to what people are used to, even though they're couched quite differently in the legislation. We don't say exactly what type of authorisation should be used for what activities, but I think there are some sort of general rules of thumb, and the bill contains criteria for when you would use each one of those, particularly a licence or a permit. So there's a set of criteria that have to be met before you could issue a licence or you could issue a permit. That tends to steer licences being for the more enduring activities and permits being for the more one-off circumstances. There's fewer controls around the permits. I do have the references there are, I'm sure you found them, 128 and 135 in the bill. The regulator also will have the ability to issue regulatory orders as another instrument for the matters that we've listed up there on the slide. And at 178, excuse me, the bill contains consultation requirements around when an order would be made to ensure that people to whom that might apply have the ability to comment on that, with the exception of the Medicines Access Limitation Orders for obvious reasons. We've also done our best to address the toolkit available to the regulator for compliance and enforcement. The Medicines Act is wanting in this respect, and the new bill contains quite a lot of tools for the regulator to encourage good behaviour, and then all the way through to criminal offences and sanctions should they be needed for the most egregious behaviour. The bill links into the Search and Surveillance Act. That's the general statute that applies in terms of investigative powers, and we've got a few additional dot pointed there, a few additional powers over the Search and Surveillance Act that are particular to this sector. The enforcement options, the particularly new ones there, are around infringement fees. So that's, people are most familiar with those as sort of parking ticket type offences, and enforceable undertakings where there can be an agreement between the regulator and the other party about actions that will be taken in lieu of enforcement action. Turning to some of the more administrative things associated with the bill, the couple of quite big changes, I think, from what we're used to. We've moved away in this bill from prescribing the types of committees that the regulator must form to help it make particular decisions. And that doesn't mean that we don't expect the regulator to have such committees. I mean, just as MedSafe does now, it will need to draw on expert advice to help it make particular decisions. But what we're trying to do is give it flexibility in how it convenes that expert advice, rather than setting up particular statutory committees with, now we've got particular memberships for something like the classification committee. We're giving the regulator a general power to establish whatever expert committees it needs in whatever form it needs them. So, for example, that would allow it to set up a panel of people. It could, convene a panel of 12 people and pull subsets of that together to give it advice on a particular issue. Or it could draw just on, if there's something presenting where really there's only one or two subject matter experts, it could go to those people, rather than having a committee set up in statute, which brings cost. It brings quite a lot of cost and administration to the regulator, and ultimately that gets passed through cost recovery mechanisms to the industry. If we felt the need to, we could also use accountability mechanisms around the regulator to require it to do particular things if we thought it wasn't perhaps seeking the input that it needed in a particular area. We could, as an accountability matter, require it to do so. So that ability isn't lost, but we just have tried to make it a lot more flexible and a lot more modern. Certainly when we've had the discussions with our Parliamentary Council drafters on this issue, they've been very clear that modern legislation does not contain prescriptive requirements, anything like the Medicines Act, in terms of expert committees. So we'll be interested in your feedback on that. We've also changed the review process for people that wish to seek a review of a decision by the regulator, and opted for a specially convened panel made up of 3 relevant experts, no conflicts, and one of whom's a lawyer with 7 years' experience. That panel would be able to review decisions and refer those back in to the regulator for reconsideration, etc., as needed. We had quite a careful look at how the review system had been working to date, and actually we found it was very, very rarely used, and that there was an opportunity to really have a much more streamlined approach, while still ensuring that there's a process there for people that may wish to question decisions. That's fine. And if someone doesn't support the decision made by the review panel, there is the ability to appeal to the court, to the district court. The cost recovery approach in regulator form are still matters you'll have seen in the Cabinet papers that are open for discussion. The decisions we've had from Cabinet to date are that the costs of the regulatory scheme can be recovered from the regulated parties to the extent they're not met by government. That's a legislative way of saying that the regulator can have a fees and charges schedule, and the government can also provide Crown funding. So there's work going on now to work out what that split should be. I know that it's a matter of great interest to people. I also have to say that we will not know exactly what those fees might be, because there will be some, for quite some time. That's quite a lot of modelling work to do. We've got to make a whole bunch of assumptions about volumes, all that kind of thing. So that's quite some way away. However, we can do the work now on what the policy should be, and is it reasonable, what cost is it reasonable to recover from the industry, and what cost should be borne by the Crown. But I think it's also fair to say that MedSafe is currently largely cost recovered from industry, and it's a reasonable expectation that there would be recommendations that a high level of cost recovery continue. The form of the regulator is also yet to be decided. MedSafe is currently a business unit within the Ministry of Health, and that option remains open for our future regulator. You'll have seen, if for those of you that made your way into the Cabinet paper, that we have moved the discussion on a bit with government, and there's now 3 choices on the table for what the form of the regulator might be. They are, as it is now, inside the ministry. That's the departmental model. There's the departmental agency model, which is sort of an independent unit within, with an independent CE. And there's also a Crown entity option, and there's a number of forms of Crown entity. So that is on our plate at the moment, and that work will be done. I think it's worth noting, though, that under any of those options, we can run whatever requirements we think are necessary to ensure that the regulator is accountable, follows due process, but is also able to get on with its business. There's a balance to be struck there. We want the regulator to be nimble and responsive and accountable. It's quite a high ask. So all of the arrangements that I imagine would be of interest to you are possible under all of those options. So that's a very quick overview. And I'll now hand to Susan to talk about the medicines and AMIs parts of the bill.
I'll just make a few comments first about scope in relation to the medicines area. Currently, under the Medicines Act, there are some surprising sort of omissions from that spectrum of products. And radiopharmaceuticals is one of those, for example. So under the new scheme, it's intended that that term medicine would encompass products such as radiopharmaceuticals that we don't regulate in New Zealand at the moment. There may well be some types of radiopharmaceuticals that are exempt from requiring product approvals, but that kind of detail will be worked through later. But we're just mindful that we're out of kilter with the developed world in relation to the radiopharmaceuticals area. The other area that is more explicitly covered in the new bill is the active ingredients for medicines, which we're using the term AMI, or active medicinal ingredient. It is more commonly referred to in overseas jurisdictions, such as in Europe, for example, as APIs, active pharmaceutical ingredients. But in discussion with the drafter, we've settled on this term for the moment, and we don't think that it will cause confusion. It's a defined term in the bill, and we think it's clear what is meant. Although we don't define it so clearly in the Medicines Act Act's got a very muddly provision early on, which does cover active ingredients of medicines, but does so in a very clumsy and awkward way. And on the face of it, it would seem that those sorts of ingredients would need a product approval, like ministerial approval. They never have done, but it's part of the wonderful muddle that is the Medicines Act. And so we want to move forward and say, well, okay, there are some controls we want on these active medicinal ingredients, but we do not want the full suite of controls that we have on finished products. So we want to make sure that when they are manufactured, the manufacturing arrangements for these bulk active materials are appropriate. So we have proposed placing controls on the manufacture of the prescription type AMIs, but we don't want, and we're not proposing, for example, to put manufacturing controls on the preparation of, let's say, salt that is going to be going into a medicinal product. I'm interested in feedback on whether you think we've got the scope right in relation to the AMIs. Should we be digging deeper? We want to control the supply chain of those, so that some of these actives, of course, have very significant potential to cause harm, so we don't want them diverted out of the licit supply chain into the mischievous one, where obviously some of them could have misuse as drugs for sporting enhancement, or whatever. But the thrust of what we got in the bill is intended to manage the distribution chain and to manage the quality assurance in relation to the manufacture of those things. The other big change in terms of the scope of what a medicine is in relation to the proposal that cell and tissue products be covered. We did contemplate, shall we create a separate category, as Australia has done, and call it, say, biologicals? How should we deal with it? We were more attracted to the European approach for handling cell and tissue products, and we are needing to have a bill that covers therapeutic products and then subdivides those into as few categories as possible. Otherwise you start to get quite a lot of difficulties with interface issues. And so we felt that it was sensible to have therapeutic products as medicines, medical devices, these active medicinal ingredients and the type 4s, but we felt that another category altogether was not going to be helpful, and that we could manage it well if we had our definitions of medicine and each of the product types tailored appropriately. The intention there is, and there's a lot of discussion needed with the cell and tissue sector, but we would be not wishing to regulate under this statute the likes of transplants where somebody's kidney, for example, was taken and placed into a donor, those sort of whole. We're looking to regulate in situations where there is collection of and then banking, preservation, storage, and manipulation. So there are kind of two ways in which the cell and tissue sector will be impacted. One will be centres where those activities are occurring would need a licence, which would be covering quality approach during the handling of those materials. And then the products that would need an approval would be those, what the Europeans refer to as engineered products, the products that are where the cell and tissue material is highly manipulated and or is being used in the recipient for a completely different function from the way it was used in the donor. And the Europeans have got some quite useful and detailed guidance on both the activity oversight and the product approval process. So we'd be looking to see how much of that material we could draw on, mindful as well of other jurisdictions such as in the US where they've also been looking at this area. But it is going to be an area that we need to as well make sure we have good interfaces with the Human Tissue Act and also with the heart legislation for assisted reproduction technologies. And those interfaces in the current version of the bill are not as well developed as they will need to be before the bill is introduced to Parliament. So there's a bit more refinement to go on that front. In relation to medicines, Sheila's mentioned language in the new bill quite different. So, but nevertheless, how things are regulated, there's a lot that will stay familiar to those who are working in this part of the industry. So again, product approval required, not given by the minister, but given by the regulator. In practice, of course, as those who are in the sector know, the delegation is down into to the ministry for medicines approval currently. A different term that's been used by our drafter for what we currently call classification of medicines. The new term in the bill is categorisation, and again reflecting that the terminology that we use at the moment, prescription, medicine, pharmacist only or pharmacist, pharmacy only or pharmacy, general sales, may shift over time. It's familiar to us at the moment, but maybe new terms might seem more apt in the future. So the drafter recommended that we stick with Category 1s, Category 2s in the bill, and then use subordinate instruments to spell out what that means. And so we would expect, probably, as we know things at the moment, that people would feel comfortable if the familiar terminology was reflected at the lower level for the time being. But if a time came where that wasn't appropriate, or for example, wash my mouth out with soap and water, let's say the day came when pharmacy medicines it wasn't needed as a category, because that's been a suggestion that's raised every now and then over time, then there'd be the possibility of dealing with that should that time come. So we've tried to keep that flexibility in place. The TRIPS related requirement for protecting confidential information that's supports applications for approval of innovative medicines is retained. The policy intent is that the same policy that we have now is applied in the new regime. The wording of the provisions is a little bit different because it's expressed, I think, in a way that's easier to understand. But obviously people may have comment on that they want to make, but the policy intent is no change in relation to that. The, again, intent is that as far as is practically possible, we would be aligning with international standards and practice in relation to the approval of medicines and the post-market management of medicine safety. As Sheila's mentioned, we continue to use licensing mostly for the controlled activities that the medicine sector undertakes, such as wholesaling and manufacturing. And obviously the pharmacy business and retail sale, and Hannah will go into those. The pharmacovigilance activities continue apace, and I'll talk about that a moment in relation to the next slide, which covers really those things where there are some differences between the now and the future. We wanted to have more flexibility to have different pathways to approval. The Medicines Act, pretty prescriptive and clunky when it comes to the application process, so we wanted to have that flexibility. And clearly, with medicine being such an umbrella term, you would need to have different pathways to accommodate the likes of the highly engineered cell and tissue products, from the generic pharmaceuticals, from the innovative chemical entities, and so on, and over-the-counter medicines, and maybe even potentially there's the possibility that you could have a lower risk tier of over-the-counter medicines that you might have a slightly different approval pathway for, that's reflective of the risk status of those products. One area which will probably have struck you when you've been looking at the bill where there is change is that using a term sponsor to mean the person to whom the product approval is granted, or a person who's dealing with an approval exempt product, either importing it or making it. And we think that those people, whether they be individuals or body corporates in New Zealand, should be fit and proper persons, as the bill says, which is pretty much a criminal history type check. And we also think it's important that they have a contractual relationship with the manufacturer, because the sponsor needs to have a direct conduit through for information about changes to the way products are made, for interacting with the manufacturer when there are any post-market incident reports to be assessed, and it is slightly troubling at the moment with some sponsors having no apparent connection with the manufacturer, and there's nothing to prevent at the moment a sort of PO box of convenience, but really there's nothing behind that in terms of a skill set that understands therapeutic product regulation, or how to follow up on quality reports or those sorts of things. So we've got some clear criteria for being a sponsor, and we've got obligations to be placed on a sponsor. So we're very interested in feedback on that. The legislation requires the regulator to publish a register of approved products, and the register would also have any products whose approval have been revoked, or pending products, so there would be transparency about that. It sets out some of the information that must be published in the register, but doesn't prevent a wider set of information being published, and no doubt there'll be conversation about that around, for example, whether the register should include consumer medicine information or prescribing information as well, or is there a better place for that to be made visible. And of course MedSafe publishes on its website at the moment a lot of information about pending and approved products through its database. Another important change is an explicit ability to recognise another regulator's work, either through reports that the regulator may have produced or interactions between the two regulators or decisions that the other regulator has made, whilst retaining the New Zealand regulator's right and need to make a sovereign decision for New Zealand about a product. But that's, I think, going to be very useful, particularly in relation to medical devices, but also in relation to medicines. And it's been one of the, working with the Medicines Act's a bit like working within a kind of a solid biscuit tin with, rigid walls, with some of which are a bit rusty. But when new business opportunities arise and people come and say, could we do this? Often the regulator has to say, well, I'm sorry, but there's no flexibility to enable that kind of thing to happen. It seems like a good idea for it to be able to be handled, but we can't do it. So we're trying to get away from that impediment. The good old provisional approval for medicines disappears as a sort of explicit concept like that, but the new approach permits conditions to be placed on products and time-limited approvals. It just doesn't dictate, in the same way the Medicines Act does, the more precise circumstances in which those sort of conditional or time-limited approvals can be given. There would be clearer grounds for cancelling an approval. No suspensions in order to not provide lack of certainty in the distribution chain if an approval is cancelled. What about all the stock in trade? And in fact the bill allows for the regulator to issue a continuing use notice in the event that an approval is revoked, and that could be because the company has lost interest in the product, not for a safety reason, or it could be because they've decided to close up shop and haven't found an alternative sponsor. So it allows, where there's not a safety concern, continued use of the product down the distribution chain till the stock is exhausted. And again, a very important new provision is an explicit requirement for the regulator to have arrangements in place to ensure that there is a safety monitoring system in place. So whilst MedSafe has a number of important programs looking at that, it's always potentially a risky thing to not have an explicit requirement for that to happen, because when efficiency reviews come round and you're looking at why what are the jobs you do, why are you doing this, if you haven't got something in your statute that really points to the need, the really important need for this activity to occur, that's not a good thing moving forward into the future. Another and final one here on this slide that I'll go back to is in relation to changes to medicines. The CMN process that is run at the moment is described differently, and the way the bill is drafted at the moment, a material change, a big change to a medicine would in fact create a new product requiring a new approval. So the bill talks about broadly two categories of change: the very material ones and the others. Each grouping of changes would be spelt out in the subordinate instruments, so there would be clarity about what they were. And again, if you look at the European law, and those of you who work in the Australian jurisdiction, there's detailed guidance of all of that, so that it would all be spelt out. The bill proposes that some changes should be able to be notified to the regulator, so they don't require an approval as such. They're notified, and they could be notified on a basis that we can set out in the detail underneath, perhaps every 6 months or 12 months. So companies could consolidate those notifications and just update in the way that happens in Europe. So that's a thought. Process-wise and time-wise, it's not intended that the CMN process be more difficult or costly to run than the current process. It's simply a different sort of thought process in relation to it, and it should give more clarity about whether an old product is being replaced by some change, or whether a new product is sitting alongside an older product. In the medical devices field, moving on to that now, our intention to pick up the global model. So that means that devices would be divided into, broadly speaking, two types. There would be the in vitro diagnostic devices, and then the other big type, the devices that are not in vitro diagnostic. Such clumsy language that you see in the models, but looking at the International Medical Device Regulators Forum model, previously the GHDF, and what Europe's doing, that's what we'd want to do. Risk classifications, picking up on that international stuff about what the risk classifications are and the rules for sorting devices into an appropriate risk class. Manufacturer having a lot of responsibilities. We can't reach overseas manufacturers through our bill. We can't reach out and ping them if they're being naughty. We have to go via the New Zealand sponsor. So the way the legislation would work is that the New Zealand sponsor, again, has to have a contractual relationship with the manufacturer, and they need to be able to access the technical documentation, access the conformity assessment information that they would produce for the regulator to show that the devices they want to sell have been subject to the required conformity assessment process, and that the player who has done that conformity assessment has been some person on the ministry's approved list. So the intention is that the new regulator would publish a list of notified, I shouldn't use the term notified body, publish a list of bodies who may undertake conformity assessment for the purposes of access to the New Zealand market. And we would expect that list would have the list of notified bodies that play in Europe with the scope restrictions that are necessary for the work they do, and it would have some trusted overseas regulators who themselves undertake conformity assessment. But we would not envisage the New Zealand regulator undertaking conformity assessment itself. In previous consultations, the sector has said they wish to have the freedom to use third-party conformity assessment bodies. Obviously, we'd be interested in any feedback if views have shifted and there is a call for the regulator to have a capability, then it'd be useful to know that. So product approval would be required unless a product was approval exempt. Custom-made devices, when they're made to the specification of an individual clinician for a particular patient, would not need an approval. They would be subject to an exemption. And we've tried to use definitions and so on that will enable 3D printing accommodated and things of that kind. So a lot of that detail for devices will be down in the subordinate instruments, so a lot of consultation to go on that. One of the questions in the consultation paper, one of the areas that we're interested in getting feedback on, is whether some of the products that don't, strictly speaking, fit the definition of medical device, but in some other countries are regulated as if they were a device, should we similarly try to regulate them through this scheme? So some of those things are things like contact lenses that have no corrective function, but they're used to go to the party with blue eyes or green eyes or something, or the devices emitting electromagnetic radiation that are used for more cosmetic or body sort of altering purposes. So Europe describes them as devices that have similar risks and operate in a similar way to many devices, but they are not intended by their own manufacturer to be a medical device. So we're interested in what people think is appropriate on that. Unapproved devices would able to be supplied once a special clinical needs assessment has been issued. Again, we're interested in feedback on how that might work. This is not a topic that applies to devices at the moment because there's no approval process, but in the case of medicines, the main mechanism at the moment for getting access to unapproved products is really not working as it should do, and there's a lot of supply which is really sort of inappropriate, sort of driving around the approval process. So it would be good to try and tidy that up. And we've had a look at what happens in the UK in relation to compassionate access to unapproved products and how to meet special clinical needs that can't be met through an approved product. So for both devices and for medicines, sometimes permits may be able to be used in particular circumstances, but generally on the one-off, it'll be the clinical needs assessment. Again, in the same way as for medicines, different approval pathways possible, and we mustn't forget that we currently have a mutual recognition agreement with Europe, so there would need to be a pathway so that devices that fall within the scope of that agreement are not subject to further assessment here, because that would be a breach of that agreement, but can come onto the market. They can be put onto the register, but without being scrutinised again. We've tried to set out some transition arrangements that will give the industry an appropriate amount of time to move from a largely unregulated state to a regulated state. So the two broad requirements into the future are that products need to be approved, and that those who are wholesaling devices need to have a wholesale licence. So what we've got in the transition provisions in the bill at the moment, and I'm aware that Faye would like us to go into this in more detail, and we can certainly do that in the session on devices in March, but the intention is that the bill itself gives 6 months from the date of commencement. Nobody has to do anything, but for that first 6 months period after commencement, those who need to get a licence are covered. All the products that are on the market prior to commencement are covered. Before the 6 month ends, those who want to keep selling their products must apply for a product approval, and that automatically allows their product to stay then on the market until the regulator has made a decision on that application. So they go through an approval process, and the application is made in that first 6 month period for the products. And similarly for those who need a wholesale licence, the application is made within 6 months of commencement, and the activity can lawfully continue until the regulator's made a decision, which would often be obviously to issue the licence, so it just carries on that basis. So that's the proposition. Happy to talk about that later on, when we get into that level of detail. That's probably all I need to say at this stage, and hand over to Hannah to cover off the licensing.
I'm aware we're a little bit over time, so I'll try and be brief, and I think we still should have time for a quick tea and coffee and at least an hour for Q&A. So I'm covering off licensing. I'm going to first just talk about some of the key changes for licenses generally, then specifically for pharmacy and clinical trials. So, as we talked about, most of the things that currently are authorised via licence will continue to be so, things like manufacturing, pharmacy, wholesale supply. The concept of having responsible persons on a licence will continue, but the obligations of the people in these roles will be clearer. We will be setting the obligations and regulations so that we can have that layer of flexibility, and they'll differ depending on the type of activity the licence is for. Obviously the type of responsible person you want for a manufacturing licence is different for pharmacy and wholesaling. It will also be possible to set qualifications where this is important for those roles. So if to be able to do the role properly you need to have, or effectively, you need to have certain qualification or training, this could be required, but does not have to be. That would be set in rules, just so that there's that flexibility, so that if you're referring to a particular qualification or training, if that changes, there's not a huge process to try and fix that up or change it. Overall, there will be more flexibility in what a licence can authorise in terms of the activities and the locations. Now, what that means is that, so for example, a clinical trial licence can authorise the clinical trial, and as part of that, it can licence the supply and use of the unapproved products, that need to be brought in for the trial, and whatever needs to happen to sort of set that up working. So you don't have to have a number of different authorisations, it's all linked into the one. And similarly with locations, if it's happening in a couple of different places, it specifies exactly what can happen and where. Licences will be able to be up to 3 years. They can be lower if for some reason the regulator considers they need, for a risk reason, to check more regularly, but it also means that if you're performing well and complying well, that actually we can sort of reduce some of the costs related to that. And then there has been quite a bit of discussion around the definitions of activities. Sort of the licences apply to activities, so obviously the definitions are quite important. Sort of manufacturing, dispensing, administration. And we're expecting that there will be further discussion about that, and happy to have that at the forums in March. In general, what we've attempted to do with the bill is to describe the activities along the supply chain more clearly, so that when we're licensing and authorising these activities, it more accurately reflects and enables what's happening in practice at the moment. Pharmacy. There's a few things in the pharmacy area where the bill has some proposed change, or where we're specifically seeking feedback on some policy behind that. I just think it's worth clarifying up front as well, because there's a lot in the pharmacy space, that the bill focuses on regulating pharmacy and pharmacist activities that involve therapeutic products. This bill is about therapeutic product. There is a lot of pharmacy and pharmacist activity that might be covered by, say, a pharmacy contract that actually doesn't involve a product, so it might just be involving clinical advice. That is actually under sort of HPCA. This is around when those activities involve a product. So we're talking about compounding, dispensing and supply of therapeutic products, generally medicines. In the bill, a pharmacy business is defined as one controlling particular activities. These are compounding, dispensing and non-wholesale supply. The reason the definition is focused on activities rather than the physical premise or physical pharmacy is in order to allow more flexibility in what we're actually licensing. So what this means is that we could license pharmacy activities to occur in different situations. They don't just have to be in a bricks and mortar pharmacy. So a pharmacist could seek a license to visit a rural primary care facility and take some medicines with them and supply that as part of their consultation and visit. They would need to be clear on where they were going, what medicines it was appropriate for them to bring, how they were going to store them securely, and the license would make sure that there were the right controls for the safe storage and security of those medicines, but it would allow that type of service delivery model to evolve. The licence and the requirements will be focused only on the activity that pharmacy wants to perform. What that means basically is if a pharmacy is not compounding, it wouldn't have to show that it had the space and equipment that you need to compound. So it's a bit more, the licence is specific to what you actually want to do. As I'm sure you've all seen, the government is specifically seeking feedback on how to ensure a pharmacist is in control of the pharmacy business. That's our starting point, that pharmacist having the control is very important. But the question is, what's the best way of doing it? How can we do this in a way that ensures that control is working as intended, but also allows sort of flexibility in how the market and pharmacy sector evolves. So the two options we are seeking feedback on is to retain and strengthen the current majority pharmacist ownership requirement and make sure that it works as originally intended, or the alternative option is to remove that, allow open ownership, but replace it with the requirement that anyone having a pharmacy licence has to have a pharmacist who is in control of the systems and settings that influence pharmacy practice within the pharmacy. As well as the bill has a lot of questions in this area because we really do want to make sure that we get good feedback on what we're doing works. So we're also seeking feedback on how we could best implement each option. Setting up these types of requirements can get very complicated, so we want to be really clear that we've got the intention of each option right, the issues, the risks we need to mitigate, and the implementation considerates all up front so that when we're working through that we can do so. And that also we're doing it in a way that is going to work within the overall new scheme and the flexibility that we're also wanting to occur. So we're trying to get that together. You'll see in the pharmacy section there's also another couple of areas where we're seeking feedback on some of the other requirements that are specific to pharmacy licences. For example, the supervision requirement of the pharmacist in the pharmacy and the strict prohibition on prescriber investment in pharmacy. We just want to check that the way these are set up are at the right level to ensure safety without creating unnecessary barriers. So we've got some specific questions on have we got that right? Does there need to be more flexibility in how those could work or not? For clinical trials, these would now be authorised via a licence. A licence will be required for clinical trials of all medicines and medical devices, so the scope of the clinical trials covered is increased. The regulator will be able to seek advice before issuing a clinical trial licence, but is not required. This again relates to that sort of flexibility of making sure the regulator can use that advice when needed, but isn't enforced to when it's not particularly useful. The requirement for ethics approval, though, has been built into legislation for the first time. This is a specific, if you look at the criteria for licences, there's a specific one that says for licensing a clinical trial, there needs to be ethic approval in place and it needs to be conformed to, because that's just a really key requirement. And while we recognise the importance of a timely approval, this is not hardwired into the bill at the moment, but we intend for there to be efficiency expectations placed on the regulator as part of the detail of the scheme and how it's implemented. So we know that timing of that approval is really important for this sector, and we'll keep a focus on that. So those are the licensing things. Health practitioner authorisations. As Sheila explained, there's a number of ways you can authorise things in the bill. But in general, licences refer to a specific person or company, so they're not particularly useful when you're trying to, they're not an efficient way when you are authorising a whole profession. So when we're authorising a profession to do something, that's generally in the legislation or in regulations. So the core authorisations for health practitioners to perform certain activities like prescribing and dispensing, supply, are in the bill. There will be more specified ones in regulations where it's a different kind of subset. So, for example, we have some real different situations around what might happen in sort of defence force situations or maritime refitters. That because of the detail, that would be regulations. But your standard ones around prescribers and pharmacists and sort of people working in hospitals are covered in the bill. In general, these authorisations reflect what they're currently to do in practice. So I know people have been noticing some of the differences in the way the activities are defined has made some of these authorisations perhaps more obvious than what it has been previously. But actually, in general, what we've tried to do is authorise what is currently allowed. There are two areas where we've proposed some changes, and so there's some questions around that. One is around this, who can supply pharmacy-only medicines, and the other is around this prescribing of unapproved medicines. But otherwise, we've tried to capture that. So, as Sheila mentioned, we have retained the 4 categories of medicines, but they're referred to as category 1, 2, 3, 4. So you start from, your most regulated prescription is 1, pharmacist, pharmacy, and then general sales. So the bill includes additional controls for prescription medicines where a prescription is required, and there will be the ability to set requirements of what that needs to be in regulations and rules. And only prescribers are able to, those who are authorised to prescribe can issue a prescription, and I'll talk about that a little bit more in a minute. The one area, as I mentioned before, where we're seeking feedback is around the who can supply a pharmacy-only medicine. The bill includes authorizations for other health practitioners and their workers. This is sort of where you look at sort of often the safety and access trade-off, and we're wondering, what we're putting out is the idea that if a health practitioner is able to administer a pharmacy-only medicine on their patient during the visit, should they be able to allow them to take some as well for after sort of care treatment, or does that person have to go via a pharmacy to pick it up? And so you'll be really interested in your feedback on that and sort of what controls would be necessary to make that work appropriately, and do people think that is appropriate? Prescribing. The bill is clearer on that ensuring the competency of prescribers is a responsibility of the relevant authority. So at the moment, the professions that can prescribe are listed in the legislation or in the regulation. What the bill does is it refers to the scopes of practice under the relevant regulatory authority. So this change only relates to where the legal basis for the prescribing authority is and the process for gaining that authority. Once a prescribing authority is in place, the role of the responsible authorities to overview the competency and clinical practice of their members is the same. Currently, if a profession is interested in prescribing, they make a case, the benefits and the risks to the ministry and minister. If approved, then that has to go through the parliamentary process in order to get some regulations made. What would happen in the future would be same situation at the start. They would need to consult, as they do under the HPCA, for any changes in scope of practice. Then they make the case to the ministry and the minister. If the minister approves it, the process can stop there and it gets reflected in the scopes of practice, and at that point they have a legal basis to prescribe. The bill will continue to allow the supply and administration of prescription medicine without a prescription under a standing order. We are aware that there are concerns around the way they're being used currently. So what we intend to do is, when we're working on the requirements for that in the regulations, we'll obviously be engaging to find out exactly what the issues are and how we can better set those up so that the requirements are realistic, effective, and ensure better safety. Unapproved medicines. This is an area where we are proposing some changes as well in the bill. We want to ensure there is a clear and considered process for allowing unapproved therapeutic products into New Zealand, as these products do not have the same safety and efficacy data supporting them. So this is an area where we're not looking to increase access, but rather ensure access is available when and only when it is clinically needed. Currently this happens via Section 29, and we think that there is ability to refine this and make it work better. The requirement for Special Clinical Needs Authority is intended to ensure that the health practitioner prescribing the unapproved product has really fully considered whether an unapproved product is the most clinically appropriate medicine for that person, whether there's any approved products that would be available, because obviously we have more certainty over the safety of those. The requirements of the Special Clinical Needs Supply Authority will be specified in the regulations, but we're not expecting them to be overly onerous. This is more about just making sure that that thought process has happened and is recorded. As Sheila mentioned, the bill is very pure and principle driven, in that technically off-label use of an approved product, if you're using it for something that's not approved, is technically at that point it's unapproved. So the bill has the requirement that the Special Clinical Needs Supply Authority will be required. We're sort of working through that and considering that and welcoming feedback, but I mean, for that kind of scenario, it would be possible to say that you have the prescription and it's just a tick box that says, I'm aware of the fact that I am prescribing this medicine for a use that is off-label. I've considered it, I'm comfortable, tick. And then you might have sort of a higher level of sort of requirement for those that have not been approved in New Zealand at all, to make sure they've considered the other elements of that. In terms of who can issue a Special Clinical Needs Supply Authority, the bill, these are not set up in the legislation, but ability to set in regulations. The intention is that for The more pure currently concept of unapproved product, those that do not have approval in New Zealand, would be limited to medical practitioners as it currently is. We realise that this is a little bit out of keeping with the other areas where we're trying to get other prescribers from different professions to do it, but we are still trying to manage the level of that's in our supply chain. But what the bill proposes to do is, once that assessment has been made and applies for that medicine for that patient, other prescribers would be able to issue subsequent prescriptions. So it wouldn't have to be every time they wanted to seek it. So it would be slightly in that way a bit wider than what's currently allowed under Section 29. But yeah, we're really happy to get feedback on that area. And then the other area is around personal imports. So as you would have seen, this relates to obviously the concept of unapproved products. So there's no regulatory oversight of these products, and with the increase of the internet and people being able to go onto online pharmacies, there's real concerns around what people are ordering and whether what they bring in, how can your general member of the public know what's safe and what a good website is, because some of them look really good but they may not be. So we really traded off the whole safety and access considerations and really thought this one through. So what we're proposing is a tightening, which we think is justifiable. The bill contains an authorization so that people can continue to bring in all medicines with them, prescription and non-medicine, onto their person, as long as, if it was a prescription, they got it appropriately in the country of origin. In terms of being able to order online and bring in via post and courier, the bill contains authorization to do that for non-prescription medicine, but the bill doesn't contain an authorization to bring in by post and courier prescription medicines. We think that the risk profile of those types of medicines, that's why their prescription means that it's really important that when somebody needs that medicine, they get a medicine that actually is going to work and address whatever their condition or illness is, and that should go through the regulated supply chain. There still will be ways of accessing it, as I discussed before, but it would have to be through the regulated way of getting an unapproved medicine. So they have to be brought in for them, rather than them just going online and ordering it themselves. So yeah, we're seeking feedback on how people think that would work in practice. This is my last slide. In terms of supply and use, obviously a lot of those other things have been focused on medicines. For medical devices, we don't have the sort of categories or classifications of them in terms of their use and supply. So there's no prescription-only medical device. However, we are aware that there are at times concerns around the way people are supplying them and using them. And some medical devices, it might be really important that there is a health practitioner using them or a certain qualification. So the bill enables the government to declare a medical device to be a use or supply restricted device in regulations. At that point, the regulations that declared it to be that type of device would then specify who was authorised to do it. So in what circumstances, whether it be a health practitioner, whether it be a certain situation or training, it would be appropriate. And again, that's sort of a future-proofing thing for where we get concerns and issues.
We have, you'll have seen when the material came out, we've got our sector forums coming up in March and looking ahead to submissions from everybody due by the 18th of April. Following April, we will of course be analysing all of the submissions that come in, looking at what we need to do to the bill, and we've got report backs to Cabinet you'll have seen on the overall feedback that we get, and also on those particular policy issues around DTCA, around pharmacy licensing, around cost recovery, around institutional form. So that's what the team will be beavering away on while you're beavering on your submissions. We'll be thinking about the institutional form. The bill, post your submissions and post Cabinet's decisions, will then be amended. We need Cabinet authority before we can draft, and then we'll be looking ahead to introducing the bill later this year, and then the next submissions round you'll be invited to participate in will be through the select committee process, and we will be going into doing all of those subordinate instruments that we've been talking about.